The social media reaction genre, silly comments are considered especially heinous. At Dear Woke Christian, the dedicated content creators who investigate these horrible comments are members of an elite squad known as the Dusty Comments Unit. These are their stories.
Grace and peace, everybody. You saw the thumbnail, you saw the title. No, you didn't. You didn't see any of that because this is a special live stream. I did not plan it. It's not scripted, anything like that. Shout out to Brother Floyd, who's been a fantastic contributor in the email space. He sent me something that I just said I got to share with all of y'all. So if you don't mind, grab your popcorn, get your adult beverage or your uh, non-adult beverage, and let's get tapped in. Let's go. What are we talking about tonight, Jason? I'm glad you asked, because court awards Judicial Watch $21,578 in fees and costs in open records lawsuit against Fani Willis. Now, we're going to read through this article, but my goodness, in the morning, instead of giving the data, the information that Fani Willis should have given because of open records, because of FOIA, she would rather cost the people of Fulton County 21 grand plus bad press plus this extra scrutiny, and she still got to give them the paperwork. Let's go. Court awards, we just said that right there. Judicial Watch announced today that the Superior Court in Fulton County, Georgia, an order granting $21,000 in attorney's fees and costs in the open records lawsuit for communications Willis had with special counsel Jack Smith and the House J6 committee. The order followed a previous order finding that Willis was in default in the lawsuit. I'm going to try to make that a little bit bigger for y'all, and I'm going to drop the link to this article in the chat as well. This is going to be huge because I think this is only going to exacerbate, because Fani Willis is like a rabid animal. She's going to hold on to these cases because they mean so much to her. They add so much validity to her. Oh, that's so much better, Jason, by the way. And I think we're going to watch. She's going to crumble under this, and Fulton County is going to suffer because they're going to have to pay for this woman's pride and arrogance. Let's just keep it going, Jason. Let's just keep it going. Let's go. The Judicial Watch filed a lawsuit in March 2024, filed after Willis falsely denied having any records responsive to Judicial Watch's earlier Georgia Open Records Act, ORA, request for communications with the special counsel, Jack Smith's office, and or the J6 committee. And there's a case right there. After finding Willis in default, the court ordered a court hearing on December 20th. We all saw that, which resulted in the order yesterday finding Willis liable for fees and expenses that shall be paid within 2 weeks of the entry of the order. The order recounts the timeline of events after Judicial Watch filed its records request. Now, here's something I'm finding very interesting. Remember, there was a lot of wrangling about, do you sue Fani Willis? Do you sue Fani Willis in the office of Fulton County DA? Or do you sue the office of the DA? Remember all that? That was with the whole sassy pants. And they really had a lot of problems with Ashley Merchant in that regard. I'm noticing here that they're saying Fani Willis. They're not saying Fulton County. They're not saying DA Fani Willis, Fulton County DA. None of that stuff. They're saying Fani Willis. I'm wondering why they're doing that. Does that mean Fani's got to come out of her own pocket? You know, she got cash and she got bread in her pocket. So let's keep going. Plaintiff, Judicial Watch, submitted an Open Records Act request to the defendant on the 22nd of August, 2023. Wow, I didn't realize it was that far long ago, by way of Fulton County's Aura online portal. The same day, plaintiffs received confirmation that the request had been delivered and would be channeled to the appropriate department, presumably the district attorney's office. The following day, the county's open records custodian sent plaintiff Judicial Watch an email confirming that the district attorney's office had received the inquiry and was asking plaintiff to simplify the ORA request. Literally 5 minutes later, before a simplification had occurred, plaintiff received a second email from records custodian. After careful review of your request, we do not have the responsive records. Okay, I think this is really bad for Fani. I think this is super duper bad for Fani because this sounds so much like what happened with that was Dexter Bond. There's so much that happened with Ashley Merchant in the same regard. And Ashley Merchant wants way more than 21K. So yeah, this is gonna go bad. Let's keep going though. This response was perplexing and eventually suspicious to plaintiff, given the plaintiff subsequently uncovered through own efforts at least one document that showed that should have been in the district attorney's office's possessions that was patently responsive to the request. Let's keep going. Defendant Willis, they're not calling her Fulton County DA, ultimately defaulted, and the court entered an order on the 2nd of December 2020. Was it the 2nd or the 20th? I say the 2nd of December 2024. I think that's supposed to be 20th. Maybe it was. Directing defendant to conduct a diligent search for her records for responsive materials and to provide any responsive records that were not legally exempted from disclosure. So, can you go back and check? This is like a teacher telling a student, can you go back and look in your book bag? Look in your desk, take everything out of your desk, take everything out of your book bag, find that permission slip. Defendant's compliance with the court's, okay, yeah, it's saying 2nd of December order consisted of an undated, unsigned 2-page memo to plaintiff from defendant's open records department. In this memo, defendant announced that there still were no records responsive to one set of plaintiff's requests, communications with former special counsel Jack Smith, but that there were in fact records responsive to the plaintiff's second set of requests, communication with the United States House J6 committee, but those were exempt from disclosure. How wild is that? Despite having previously informed the plaintiff 4 separate times that her team had carefully searched but found no responsive records, now there suddenly were, but they were not subject to disclosure under ORA. The ORA is not I don't know what that word is. Hortatory. I want to say horticultural. I have no idea what that is. It is mandatory. Hortatory. It sounds like they're saying basically it's not voluntary. That's what I'm getting. It's mandatory. Non-compliance has consequences. One of them can be liability for requesting parties' attorney fees and costs of litigation. The court concludes this criticism of Willis's actions, stating, again, they don't call her the district attorney's office. Now, I do see that they mention it in here, but that's just really interesting to me. Let me keep this going. Most basically, by operation of the law, defendant acknowledges violating the ORA when she defaulted, but actual evidence proves the same. Per her records custodian's own admission, the district attorney's office flatly ignored the plaintiff's original oral request, conducting no search and simply and falsely informing the county's open records custodian that no responsive records existed. We know now that that is simply incorrect. Once pressed by the court order, defendant managed to identify responsive records, but has categorized them as exempt, even if the records prove to be just that, exempt from disclosure for sound public policy reasons. This late revelation is a patent violation of ORA, and for none of this is there any justification, subsequential or otherwise. No one search until the prodded by civil litigation. Given this, the court finds that relevant and responsible attorney's fees and costs of litigation are properly rewarded to the plaintiff. Plaintiff. Defendant is thus liable for the plaintiff of $21,000 pursuant to the OCGA squiggly line 501873B. This amount shall be paid within 2 weeks of the entry of this order. She's right. It's a wrap. It's a wrap. In early December, Willis finally admitted to having records showing communications with the J6 committee, but refused to release all but one document in response. The court order that found her in default. She cited a series of legal exemptions to justify withholding the communications with the J6 committee. The only document she did release was an already public letter of the J6 committee chairman, Benny Thompson, a Democrat from Mississippi. Judicial Watch subsequently filed a motion in asking for the court to appoint a special master to oversee the district attorney Fani Willis's search for records in the Judicial Watch lawsuit, and that the court to conduct an in-camera private inspection of any records found. Again, all of this could have been avoided if she just gave in and turned in the information. But I'm pretty sure it's probably way more damaging than we know. I'm pretty sure it definitely doesn't show what she wants it to show, or it definitely shows what she doesn't want it to show, for sure. Let's continue. Judicial Watch stated in his motion that Willis' response to the order makes no showing that the search was diligent based on her previous searches in this matter. 1 second. We're going to take a coffee break. 1 second. Un momento, por favor. And just like that, we're back. Based on the previous searches of the matter, it probably was not diligent. Likewise, she provided no list or even a general description regarding any responsive records that she had elected to withhold. Without a list of descriptions, it is impossible to evaluate what, if any, exemption or exceptions are applicable, as she now contends. Okay, I'm going to have to say I don't know this, but because I'm not a legal mind at all. I'm a pre-K law student, and I failed a lot of my pre-K law classes. But if they tell you, hey, these are some documents I'm keeping away from you, it's my conversation with Nancy Pelosi. I think, unless it's legitimate, that it's something that's redacted or something that she can withhold. Well, now they know that you had a conversation with Nancy Pelosi, and they can kind of press on that. To me, I don't know how they go about showing, like, well, this is the stuff I'm keeping away from you. Why? Because that kind of defeats the purpose of keeping it away from them. Regarding the appointment of the special master, Judicial Watch states, Willis, by her own admission, conducted at least 3 searches before finding any responsive records not already supplied to Judicial Watch. She did not even bother to conduct a search until the complaint was filed. Her records custodian says that he does not know the Cellbrite digital investigation equipment he apparently had a hand in ordering can be used to search cell phone texts and other data. I didn't know that either. I didn't know because could search text messages. Moreover, the custodian had no standard practice in conducting searches and keeps no records of the methods used in giving search. The foregoing gives rise to grave suspicion that all responsive records have not been found. The court should appoint a special master to supervise and monitor the record search. The special master should have authority to audit searches and conduct searches herself. This is crazy. And Fulton County is going to have to pay for this. Shout out to Fulton County. You reelected Fani Willis. Just letting you know that. Just letting you know. Now, I don't know how it would have went if Courtney Kramer had come into office, but we see right now what we got. Yeah, shout out to y'all, Fulton County. Y'all did it yourselves. She also should have authority to hire such custodians and experts as may be needed to execute her commission. The special master should make a recommendation to the court as to how her fees and expenses should be allocated among the parties, taking into consideration whether she finds responsive records that Willis should have found but did not. Wow. They are enjoying this, man. Shout out to Judicial Watch. They are enjoying this. Fani Willis's response to Judicial Watch requests for the special master is due on January 16th, 2025. So we got about 9 days. Fani Willis flouted the law and the court is right to slam her and require at a minimum the payment of the nearly $22,000 to Judicial Watch, said Judicial Watch President Tom Fulton. But in the end, Judicial Watch wants the full truth on what she was hiding, her office political collusion with Pelosi January 6th committee to get Trump. Judicial Watch is assisted in the case by John Monroe of John Monroe Law of Georgia. Judicial Watch has several Freedom and Information Act lawsuits related to the prosecution abuse targeting Trump. In February of 2024, the Department of Justice asked a federal court to allow the agency to keep secret the names of the top staffers working on special counsel Jack Smith's office that is targeting former President Donald Trump and other Americans. Before his appointment to investigate and prosecute Trump, special counsel, they misspelled special right there. Special counsel Jack Smith previously was at the center of several controversial issues, the IRS scandal among them. In 2014, the Judicial Watch investigation revealed that the top IRS officials had been in communication with Jack Smith, then Public Integrity Section, about the plan to launch a criminal investigation into conservative tax-exempt groups. Read more here. Yeah, if you just popped in, I'm going to drop the link to this. This article is really interesting, I have to say. And I'm dropping the link here just in case you want to check it out yourself. I'd advise you check it out. It looks like a lot of good information that I'm not going to be reading over. In January 2024, Judicial Watch filed a lawsuit against Fulton County, Georgia, for records regarding the hiring of Nathan Wade as a special prosecutor by District Attorney Fani Willis. This is the only time I've seen her called District Attorney Fani Willis. Wade was hired to pursue unprecedented criminal investigation and prosecution against former president, now President-elect Donald Trump, and others over the 2020 election disputes. In October 2023, Judicial Watch sued the DOJ for records and communications between the Office of U.S. Special Counsel Jack Smith and Fulton County, Georgia District Attorney's Office regarding requests and receipt of federal funding assistance and investigation of former president, now President-elect, and his 18 co-defendants in the Fulton County indictment of August 14th, 2023. To date, the DOJ is refusing to confirm or deny the existence of records, claiming that to do so would interfere in the enforcement of proceedings. Judicial Watch litigation challenging this is continuing. Judicial Watch's litigation challenging this is continuing. Through the New York Freedom of Information Act in July 2023, Judicial Watch received an engagement letter showing New York County District Attorney Alvin Bragg paid $900 per hour for partners and $500 per hour for associates to the Gibson, Dunn, and Croucher law firm to pursue suing Representative Jim Jordan, Republican from Ohio, in an effort to shut down the House Judiciary Committee's oversight investigation into Bragg's unprecedented indictment of former president, now President Donald Trump. In his new book, Rights and Freedoms in Peril, Judicial Watch President Tom Fulton details a long chain of abuses officials and politicians have made against the American people and calls readers the battle for the soul and survival of America. All right. Wow. All right. So if you're just jumping in, we're just having a good time reading that Fani Willis lost that case against Judicial Watch, and she got to cough up $21K. So again, shout out to you, Fulton County. Shout out to y'all. Y'all did great. Perfect. So now y'all getting hit with a $21,000 fee. I'm pretty sure it's going to only exponentially increase. And this is only one. I'm sure there's multiple more lawsuits that are coming. What could you have done, right? Maybe not hired her again. But y'all, I appreciate y'all stopping through. This was a very, very impromptu live. Again, I want to say shout out to Floyd. He's been a great supporter in the comments as well as in the email. He sent me this. I said, oh, I got to do it right now. Didn't even think about it. So we had to jump on it. Okay. And we will definitely keep you all posted. So I want to say thank you again. Every last one of y'all. There's almost 80 of you all that jumped on with me. If you could, hit that like button. If you're not already a subscriber, help my brother out. Subscribe to the channel. I'm trying to hit 50,000 subscribers by the end of April of this month, this year. I got a long way to go. Help me out a whole bunch. I really appreciate it. And if you don't mind, do me one more favor. Comment down below. Let me know what you think about it. Feel free to give me all your thoughts and opinions. And until next time, everybody, grace and peace.
Yo, hit that like for Deal Christian. Yo, for Deal Christian, smash that bell for DWC. Yo, smash it, just smash it. Hit that like for Deal Christian. For Deal Christian, smash that bell for DWC. Yo, smash it, just smash it. Hit that like for Deal Christian.